Everybody, good afternoon or good morning to those of you on the West Coast, and welcome to our webinar on hot topics in U and VAWA cases. My name is Amy Cheung. I'm a senior legal counsel at ASSISTA, and I'm joined today by my wonderful colleague, Flores Bachman, also senior legal counsel at ASSISTA.
Hi,
and
everyone.
for those of you And for those of you who've been attending our private webinars, Laura is a familiar voice to you by now, but for anybody who hasn't, this is Laura's first webinar for the OVW and STOP grantees. And so welcome, Laura. We're so glad to have you with us today.
Thanks. Glad to be here.
And today's webinar, along with all of our OVW-sponsored work, is supported by the Office on Violence Against Women through the U.S. Department of Justice. And we are extremely appreciative to OVW for their support for ASSISTA's work and for sponsoring this webinar today. And just as a note for everybody, there are a number of documents that we've made available in the Files section on the bottom right-hand side of your screen. These are documents that we'll be referring to here and there during today's webinar that we think could be helpful for further reading after we finish up today. These documents are not OVW documents. They are just made available in case they're helpful for you for further reading. Also, today's webinar has been approved for 2 hours of substantive credit through the Texas State Bar. And so for those of you who are barred in Texas and would like CLE credits for attending today's webinar, if you already entered your bar number in the registration form for today, then we will submit that information to the Texas Bar automatically, so there shouldn't be anything else that you need to do for that. If you notice that in a couple of weeks the credits are not showing up in your account, shoot us an email and we'll see what's going on. If you are barred in Texas but you didn't submit your bar number in the registration form, or if you're barred in another state and you need a certificate of attendance to submit to the bar authorities on your own, then we would ask you to email at us. I'm going to put the email addresses into the chat box right now. And you would need to email us with your bar number and the state in which you are licensed, and then we will send you the certificates of attendance so that you can request those credits. Okay. And with that preliminary stuff out of the way, we can get started. All right. So for today, we're going to be covering some of the topics that keep coming up in TA and whenever we're talking to practitioners about what's going on in the field with USCIS these days. And so some of the topics are continuations of conversations that we started in December's webinar, and others are ongoing issues that have been going on for a while, and others are newer topics. So we'll be going over some strategies for responding to fee waiver denial, as well as continuing our conversation on determining the validity period of U non-immigrant status when the I-94 and the I-797 approval notice conflict. Also, issues regarding discretion in U visas, including responding to requests for police reports, and then troubleshooting administrative issues with USCIS, specifically issues relating to missing documents and USCIS losing documents that were submitted. And the goals for today's session are that by participating, you will be better able to identify current challenges in presenting and preserving VAWA and U visa applications, fashioning strategies for meeting those challenges, and also exploring best practices. All right, so let's get started with fee waiver denial. And so I thought we'd start off with a poll just to see if there are any recent developments in this. Obviously, we know that these fee waiver denials have been going on for quite a while at this point. But if you could respond to the poll to say in the last 3 months if you have noticed an increase, a decrease, or no change in Vermont Service Centers, VSC's, fee waiver denials. And as always, poll responses are completely anonymous, and so it's just a way to get a quick snapshot of what people are seeing in the field, and just an overview of people's experiences. But all the responses to polls throughout today's webinar will be anonymous. And as always, if there's anything that people want to share with the field, more specifically, then you can put it into the chat box, and that will be visible to everybody. All right. So it looks like we have a decent number of responses at this point, and it looks like the vast majority of people have seen an increase in denials of fee waivers from Vermont in the last 3 months. A couple people have seen a decrease, which is great, and a number of people have reported no change. So we can go ahead and end this poll. So that's helpful to know, and I would say that's fairly consistent with what we've been seeing through TA. What would you say, Laura?
Oh yeah, definitely. The majority of the TAs we're seeing, unfortunately, we've been seeing an uptick rather than a decrease. But I'm also glad to know that a couple of people have seen a decrease.
Yeah. All right. So next up, just one more poll on fee waivers. So when Vermont has denied one of your clients' fee waiver requests, you have, and you can select all that apply here. And if you do select other, if you wouldn't mind sharing what it is that you've done in the chat box, that would be really helpful.
We do have a comment from Maria Jose Fletcher, who says, since we started following assistive practice pointers, all of our fee waiver requests have been approved, which is also wonderful to hear.
That is wonderful. I will say that we've certainly heard from people who have followed practice pointers and still had their fee waivers denied. But it's great to know that it's been working out for you. And obviously, we still do continue to recommend that people follow our practice pointers on these. And so looking at the poll results, it looks like the vast majority of people are resubmitting the fee waiver packets with additional evidence and or briefing. Some people are resubmitting as is. Some people are requesting supervisor review. Some people might be doing all of these. And one person has filed the 290B motion or appeal on the denial of the fee waiver. And then we have some others. My goodness.
Exciting.
So we're going to be talking. I'm sorry, go ahead.
No, I'm just really excited to see that. So far, I haven't heard of anyone filing the I-290B motion to reopen or reconsider the actual fee waiver. So I'm excited to maybe have that person share a little bit more later on in our presentation.
Yes, we'll be getting into that in much more detail. So if that person is willing to share their experience, we would definitely be interested in hearing that. And Victoria says that she has told the client that they will regrettably need to get the filing fee together, staggering the fees if necessary. So it sounds like filing, one fee that has a form and then another one and then another one if you need to space them out. And so that is also a strategy if you can't get the fee waiver approved, which in many cases has been the result that we've been hearing from people. So the strategies that you all are reporting in the poll are pretty consistent with what we've been hearing from other people as well. And so let's just walk through those trends here to make sure we're all on the same page. Generally speaking, the trends that we've been seeing over the past several months, really since the end of July, are that Vermont has been denying fee waiver requests, including for humanitarian applications, with little to no explanation. The adjudications seem quite random. Sometimes people will be submitting the exact same evidence and information for two members of the same household. One is approved and the other is denied. Other people have reported that they have resubmitted the same packet with the same evidence multiple times for the same client. And you might have a couple of denials followed by an approval. And all of this really just goes to show you how incredibly random and arbitrary these fee waiver adjudications are, and also how frustrating it can be for practitioners and for clients as well. And then we're continuing to see that denials of fee waivers can arrive after the filing deadline for a 485 or 290B or any other kind of time-sensitive application, which obviously causes some implications for the timeliness of a resubmission. And then Daniela is saying that she's received incomplete fee waiver denials with no reason for the denial. We have seen that a lot. It's very common that they will send you the blue notice saying that the form has been rejected, and then they might refer to the G1054, which is the fee waiver denial notice, or they might not. Sometimes they'll include it, sometimes they won't, and even if they do include it, there's usually little to no explanation whatsoever. So it's all incredibly frustrating for everybody, and what you guys are saying now is completely consistent with what we've been hearing from everybody else as well. As a quick question, has anybody so I know that some people said that they did, when you flagged the resubmissions for supervisory review, have you gotten any response? And if you have they been helpful? If anybody would be willing to share their experience in the chat box so that we can all learn from each other, that would be great. I'm going to move on, but if anybody does have anything to share, feel free to just type it into the chat box, and then we can talk about it when it comes up. And so the primary issues that we're seeing with fee waivers are that sometimes it cuts off eligibility, like when you have a time-sensitive application, and sometimes it doesn't, right? And so if the denial of the fee waiver has not cut off eligibility, then generally speaking, we're recommending exactly what you guys are doing. Resubmit the fee waiver application with a cover letter and additional evidence, and explaining in your cover letter why the additional evidence and the already submitted evidence is sufficient to show that your client has a financial hardship or has income under 150% of the federal poverty guidelines or is receiving a means-tested benefit. And in the file section, we do have a document titled Appendix Sample Language. And so it lays out a few different scenarios that we've been seeing in the fee waiver context and gives you some sample language to help you start your cover letters and figure out how to address these evidentiary issues for fee waivers. And then in some cases, you might find that there really just is no additional evidence available. And so sometimes it does work to resubmit with the same evidence because it'll get in front of a different adjudicator and maybe the result will be different. If you're going to do this, then we would recommend definitely including explanation for why what you're submitting is the best evidence available. Why isn't there other evidence? What efforts have you made to look for other evidence, and why is this what's available? And you would do that through a client's affidavit explaining what's out there and what they've tried to do, and then also addressing the legal arguments in your cover letter as well. But then what if denial does cut off eligibility? And so this is one of the really tricky issues that we keep running into, where the denial has arrived after the filing deadline for maybe year 485 for a U visa or a 290B. And now if you resubmit, it's going to be untimely. One of the problems that we're seeing is that if you resubmit, you get a new filing date. And generally speaking, USCIS is not going to backdate the filing receipt. There might be isolated exceptions to this, but as a general rule, your filing date is when you resubmit. And so one of the strategies that we've been talking about to get around this is the idea of filing a 290B as a motion to reconsider the fee waiver denial as opposed to refiling. And we think the advantage of filing a motion as opposed to refiling is that the motion keeps your original filing alive. And if it keeps your original filing alive, if they eventually approve the motion to reconsider, then it should preserve your original filing date, which would be really key in these cases where you potentially miss the filing deadline if they denied your case after the deadline. There are a couple caveats with this. So first is sometimes USCIS will deny the fee waiver and sometimes they'll reject it. If they reject it, you can't file a motion. There's no motioning or appealing with a rejected application. So you would have to see if they have denied the application, and they would deny it on the G1054. So if they've denied it, then theoretically you could file a motion. And you could file a motion to reconsider or a motion to reopen. But we think that the equitable arguments for a motion to reconsider are stronger. Because with a motion to reconsider, essentially what you're arguing is that the fee waiver was only denied through USCIS error. What you provided to begin with was already correct and sufficient. And so it was USCIS's mistake that caused the denial. And so as an equitable argument, they should fix their own error and grant the motion to reconsider. In theory, a motion to reopen would also be a viable option. We just think the equitable arguments aren't quite as strong. And Laura, what about an appeal? How would you file an appeal on the denial of a fee waiver?
Well, the one issue with filing an appeal on a denial of fee waiver is that the fee waiver specifically says there is no appeal from a denial of a fee waiver. So I guess the first issue is there anything that can be appealed? Because it's a discretionary application, right? That whether or not a fee will be waived is completely discretionary. They may or may not decide to do it. I don't think that the appeal generally will be the way to go. One thing I was going to point out is what the other argument that you have in many of these fee waiver denials, if you're doing your motion to reconsider, is not only that they were wrong in the evidence, but in most cases, as we saw from our poll and as many of you have seen, where they don't even articulate the reason for the denial, you should also point that out. The regulations at 8 CFR 103.3, it specifically says for all denials of any kind of immigration benefits or applications, the officer shall explain in writing the specific reasons for the denial. So if there are no specific reasons for the denial in the form that you receive, I think that's definitely something that you want to specifically point out that it's contrary to their regulations and therefore it should be reconsidered.
Thanks, Laura. So yeah, in terms of appeals, there is this regulatory prohibition, and so the likelihood of getting the AAO to accept and approve and grant an appeal on this kind of issue is probably an uphill battle, to be frank. If you were to appeal, then our strategy would be to frame the argument in terms of legal error, right? So failure to consider the evidence, and you can also frame their failure to provide any kind of explanation as to the denial of a fee waiver in terms of legal error as well. So these are just some strategies that we're batting around. And for the person who says that she's or he has filed a 290B on the denial of a fee waiver, would you be willing to share your experience in the chat box as to whether or not this has worked, if you've gotten a result yet? Because this is a strategy that we've been talking about that we think should be legally viable, but we haven't been able to see whether anybody has tried it or how USCIS is looking at this kind of strategy yet. So it's something that we definitely want to hear about if people are trying the strategy and what's been happening. And then the other thing that I just wanted to reiterate is that if you guys attended our December webinar, we talked about other strategies, including asking the AAO to reopen sua sponte, asking USCIS to reissue the denial notice with a new date, to reopen like a new period of appeal, going to federal court. All of these are also strategies that we think are still viable. We just wanted to get into a little bit more discussion about this 290B strategy. The other thing that I wanted to flag is that if you do have clients who are at a point where you're not really sure where to go, please consider submitting a TA request. We're happy to help you think through other strategies as well.
Before we move on, really quickly, so Vanessa asked a question where the reason for the denial is just, they do include a reason, but the reason is just there was insufficient evidence, but it doesn't provide any more than that. And obviously a lot of evidence was presented. So what should someone do in that situation? Would you still, how would you frame that argument in a motion to reconsider, for example?
Well, assuming that it is a situation where we would do a motion to reconsider, right, where the deadline's been cut off because of the denial of the fee waiver, then I would frame it in terms of a violation of the regulation that Laura mentioned earlier under 103, I think it's 103.2, where USCIS is required to provide reasons for a denial. And I would argue that saying that there was insufficient evidence and only that there was insufficient evidence without any description of why the evidence that you submitted was actually insufficient is not compliant with that regulation at all. And what you're seeing, Vanessa, is very consistent with what we've been hearing from other folks, where on the denial notice, there are a couple of boxes that the officer can check as to the reason for the denial, and they don't provide any explanation. There are boxes on there for the officers to explain in more detail the reasons for the denial, and they never fill them out, at least not that I've seen. They just check one of the boxes with no additional explanation whatsoever. So we would argue that checking a box on that form is not compliant with the regulation, and that would be grounds for either a motion to reconsider or potentially even an appeal if you were to approach it that way.
And if it's not a case where the denial cuts off eligibility, then I think, like Amy mentioned before, what you would do is perhaps resubmit all that evidence, assuming you're not able to get additional evidence, resubmit all that evidence, but include a detailed description of why it is sufficient and why the very cursory denial, shows that the officer really didn't take into account the evidence previously submitted.
And then after you've responded to the denial, either by refiling the case, briefing the arguments, explaining why the evidence was submitted, or filing a 290B or whatever strategy you've decided upon, we do recommend additional advocacy. So we know that responses from the Vermont hotline have been kind of hit or miss, but it's still open, and we're still hearing that people are sometimes getting responses and sometimes they're helpful. So we would still recommend submitting a supervisory review request, following up on the hotline. Likewise, the ombudsman is very backlogged, we know, but it's still worth submitting a case assistance request form to just keep your options open to make sure the ombudsman office knows that this is continuing to be a problem, and to make as many people within USCIS aware of the problem as possible and make your record. And also sometimes it helps. Also, for anybody who's not familiar with our intervention request system, we do have a couple of contacts within USCIS to whom we can escalate issues for things like stuck cases, erroneous denials, other errors, things like that. And so if you submit a technical assistance request to us, then we can walk you through the process for getting an intervention. And frankly, it's one-way communication at this point. We send them the request, and they sometimes will do something about it, and sometimes they don't. But it doesn't hurt, right? I mean, with all of these strategies, it won't hurt. And then the last one is congressional assistance. And for anybody who hasn't done it before, your client must have representatives and senators from their state who represent them in Congress. And these representatives and senators typically will have a constituent relations and constituent assistance staff to help intervene in problems with government agencies, with federal agencies. And so one strategy is to reach out to your client's congresspeople to see if they can reach out to USCIS on your client's behalf. And again, sometimes this works, sometimes it doesn't. They're probably at least going to get an answer. They'll at least get some kind of response from USCIS, whereas you may not get any response from the hotline, and we may not get any response from USCIS. And also, if you are requesting congressional assistance, then one thing that we are asking people to do is let us know if they're doing that, just so we can keep track of how well it's working. And I'm putting the link to a Google form that we've created into the chat box. And the purpose of the form is to let us know about any follow-up efforts that you've made on fee waiver denials, to whom and with what result. All right. And Laura, I think you're up.
Okay. So we're going to move along from the hot topic of fee waivers to another issue that we've seen affecting adjudications of U non-immigrant status extensions or U adjustment of status. So we're going to be talking now about the validity periods. All right, so what's the problem we've been seeing? The main problem is that there's been a conflict between the, in many cases, there's a conflict between the I-94 validity period and the validity period on the I-797 approval notice. So the I-94, everybody knows, is the arrival departure record when a person's in the U.S., the I-94, when the person's in the U.S. and U visa status is approved, the I-797 approval notice will include the I-94 card at the bottom, but it's really the I-94 card that, that gives the person the status, right? That is the proof, I should say, of U status in the United States, and the validity period included on the I-94 is what's controlling, okay? And why is there confusion? The confusion has come because the prior practice of the Vermont Service Center was that if there was a different date on the I-797 approval notice from the date of expiration on the I-94 arrival departure record, then Vermont Service Center would use the I-797 approval notice expiration date as controlling. And this really would usually come up only in cases where a person was outside of the United States for whatever reason and at whatever time after the adjudication of the U petition. So when they would come in, CBP would give that individual an I-94 card, and we'll go into why the dates would be different. But that's where the discrepancy would come in. The date given by CBP at entry on that I-94 card was different from the I-797 approval notice of the U petition. So Vermont Service Center changed their practice, and now pretty much their practice is in line with using the most recent I-94 to determine the period of validity, which is what they do in most non-immigrant cases, right? And so the result has been that many people relied on Vermont Service Center's prior practice, right? They submitted the adjustment application when the person had a approval notice, I-797, that was still valid. The person was physically present in the United States for more than 3 years, and they presumed that that person was in valid U status based on that I-797 approval notice rather than basing it on the I-94. So the result is that now, because Vermont is going by the I-94 expiration date rather than the I-797, we've seen many U adjustment of status denials where the I-45 application for adjustment of status was filed after the expiration of the I-94 card. In other words, the person was out of status at the time that they filed the I-485. So let's look at where this change in USCIS interpretation comes from. While USCIS has not specifically cited the regulations in their denials, or at least not the denials that we've seen of adjustment of status cases that are affected by this issue, while they haven't cited the regulations, this new practice is pretty much in line with their treatment of non-immigrant visa holders in other visa categories. And so when you look at the regulations, general regulations for non-immigrant visa entries include 8 CFR 235.1H, which indicates that CBP, not USCIS, will control the period of admission when a person is presenting themselves at any port of entry, right? So if the person is coming from outside the U.S. into the U.S., it's not USCIS that would determine the period of admission, it's CBP that has that jurisdiction. So that's the first regulation that affects this. The second regulation that may affect a person's period of authorized stay is that there's a regulation in the U regs, so 214.14G1, and that regulation says that the initial period, so the first time a U derivative is coming into the United States, so their initial period of admission of a U derivative can't exceed the expiration date of the U principal, okay? So oftentimes we might see a U derivative who is outside the United States and for whatever reason can't come in, you know, quickly after the U principal receives status. Usually it's an issue of, you know, they've got to get their passport documentation. Sometimes it has to do with, you know, getting the money together for the person to be able to travel or, you know, pay different fees. And so there's a lag between when the derivative is coming into the United States. And so what happens is when the derivative finally gets their visa and their passport and presents themselves at a port of entry, by that point it might be that while their approval notice has 4 full years, if they're coming in a year or two after the approval notice was granted, well, CBP is not going to give them 4 full years at the time of their admission at the point of entry. CBP will look at the expiration date of the principal and give them the time from the day that they are entering the United States through that expiration of the principal. So that's where that U regulation will affect the date will affect the validity period of their status. And then the final issue is that may affect that validity period is the validity period of the passport. All non-immigrant visa holders who are entering the United States must have a passport that is valid for 6 months beyond the period of admission, right? So if you are asking for 4 years at the time that you are admitted, then your passport has to be valid from that date of admission 4.5 years, right? So 4 years beyond, 6 months beyond the period of admission that you are requesting or that you are entitled to. So those 3 things are all coming into play, right? CBP controls the period of admission. The initial period of admission for a derivative can't exceed the principal. And if the derivative has a passport that's not valid for 6 months beyond what what the time period could be at admission, then CBP is going to basically give them only the amount of time that will coincide with that passport expiration, right? So there's a lot of things going into play there. And so what do we do, or how does this matter? When anyone is consular processed, they're going to be affected by this, right? So it could affect principals and derivatives. I gave the example of derivatives specifically because I was pointing out that regulation, but it does affect principals as well, right? If a principal is applying from outside the United States and then coming in, then it affects both the principal and the derivative. If the principal is in the United States, when their U visa status is initially approved, but then the U principal travels outside of the United States, obtains a U visa, and then is coming back in, then they're going to be issued a new I-94 card. They do not keep the I-94 card that was initially given by USCIS. And that has caused some confusion too, right? Because now they have two I-94 cards. The I-94 card that was issued with the I-797 approval notice, and then the new I-94 card that they're issued when they come back in. It's only the most recent I-94 card from their most recent entry that establishes their period of authorized stay and U status. And then the other issue, obviously, is for principals and derivatives who, travel in more than once. You've got to keep track of just their very last entry, and so it really requires us to make sure that we know of every entry and exit, especially for those clients who are able to obtain a U visa and have a multiple entry visa that's valid for several years. Sometimes they are going to be traveling back and forth, and we have to keep tabs of that final entry, because that's the one that's going to matter for the maintenance of status. Okay. So what do you do if you have this issue? First of all, check I-94 expiration dates immediately in all your cases if you haven't done this already. I'm sure you all have a tickler system or something that you use in order to check expiration dates. But for those organizations, especially for those organizations that after the U visa petition is approved, you close out the file, right? Because you have done your work, you have completed, whatever work you had on that contract, and so you close out your client's file. I think in those cases, absolutely, it's very important before you close out the file, you make sure, check the I-94 expiration date with your client. Make sure that your client is aware of what that I-94 expiration date means and what the next steps that they have to do, right? So your I-94 expires in 4 years. After 3 years, your continuous physical presence and U status, you may be eligible for adjustment. Come back to us then, right? So now it's on the client, but the client understands what that I-94 means, and that it's the I-94 that controls. And then, of course, you want to talk to your clients about travel outside the United States, right? That they would have to get a visa to come back in, what that visa process is. Obviously, it's different for every client, where there may be grounds of inadmissibility that kick in. So those are the conversations you're having, and that's why it's important to look at that I-94 expiration date in all of your cases to make sure that if there is a discrepancy between the I-797 and the I-94, that you're tracking that, or that the client's tracking that and is aware of it. If the client will accrue 3 years of continuous physical presence before the expiration date, then obviously you want to file the I-485 before the I-94 expiration, before the I-94 expires, right? They've got their 3 years, the I-94 is still valid, they're eligible to adjust. If the client won't, so if you check the I-94 card, and let's say it's for a client that's outside of the United States coming in, and they will not accrue the 3 years of continuous physical presence before the expiration date, then you have to file Form I-539, which is to request an extension of status, and you have to file that form before the I-94 actually expires, right? They have to be in status when you file that. So a quick note about that. There is in your materials the USCIS policy memo on extensions of status, and the policy memo in there, this has been a little bit confusing for people as far as how early can you file, right? Because we've had some people that have noticed, oh, the derivative came in and they were only given a year. I may as well file an extension now because sometimes these extensions take forever to obtain. Let's get them their full 4 years and let's do it now while we know that there's already an extension. Well, the USCIS policy memo on U extensions, and Amy put it in the chat box as well, but it's also in your materials.
It's actually not in the materials, it's just in the chat box, guys.
Oh, no, it is in the materials. Sorry, Amy, I had asked them to include it in there, so it's in there too. Sorry.
Okay.
So the policy memo, although this is not in the regulations, the policy memo says file no earlier than 120 days from the expiration date, right? So that's important to know, and we have seen the problem is, unfortunately, as with